Case 1. Arlen Kaufman and Linda J. Kaufman. Newton, Kansas. The Kaufman House of Horrors. Late 1970s through 2004. The names are Arlen D. Kaufman and Linda J. Kaufman. And before you hear a single detail of what they did, understand this. They did it for more than 20 years. 20 years of documented abuse. 12 formal complaints filed with the state of Kansas. 12 times someone said something is wrong inside that house, and 12 times the system looked the other way. By the time the FBI finally kicked in the door, 6 people were still inside, living conditions that federal prosecutors would later compare to a war crime. This is not a story about one bad night. This is a story about what happens when evil is given time and cover and the silence of institutions that should have known better. Newton, Kansas. Harvey County. A small town about 25 miles north of Wichita. Population modest. Community rooted. A place where people mind their own business, which, as it turned out, was exactly what Arlen and Linda Kaufman were counting on. Linda Kaufman held a registered nurse license. Arlen held a doctoral degree in psychology and a clinical social work license. Together, they opened the Kaufman House Residential Treatment Center, a group home for severely mentally ill adults, mostly diagnosed with schizophrenia and schizoaffective disorder. These were people who could not always articulate what was being done to them. People whose complaints could be dismissed as symptoms of their illness. People who had no one powerful enough to fight for them. Arlen and Linda knew exactly who they were choosing. The residents came to Kaufman House because they needed help, because their families were desperate and exhausted and believed they were placing their loved ones somewhere safe. They paid for care. They paid for therapy. They paid for what the Kaufmans described, with straight faces and professional language, as treatment. What they were actually paying for was slavery. From the beginning, Arlen Kaufman developed what he called nude therapy. Residents were forced to remove their clothing and remain naked, sometimes for extended periods, sometimes while performing labor, sometimes while Arlen videotaped. These were adults with severe mental illness, medicated, vulnerable, cognitively compromised, and they were being stripped, filmed, and told that this was treatment, that this was healing, that Arlen knew best. The labor was not optional. Residents were ordered to work on the Kaufman's farm, fence mending, livestock tending, physical field work, done while naked, in the Kansas sun and Kansas cold, with no choice and no ability to say no. Because Arlen controlled their medication. He controlled their food. He controlled when they slept and when they woke and whether they were allowed to speak to their families. Linda managed the daily routines, dispensed the medications, and stood as the professional face of the operation. When family members grew suspicious and called the facility, Linda answered. When social workers came for inspections, Linda was there, composed and credentialed, with medical records and clinical language that explained away every concern. The abuse escalated over time in the way abuse always does when no one stops it. Residents were ordered to shave each other's genitals. They were ordered to masturbate in front of Arlen. They were ordered to fondle one another. Arlen filmed everything. And in at least one documented instance, a stun gun was applied to a resident's genitals. Read that again. A stun gun. Applied to the genitals of a person with schizophrenia who was living in a group home, who had nowhere to run. When residents told family members what was happening, Linda had the answer ready. These were delusions. These were symptoms of mental illness. These people could not be trusted to accurately report reality. And because the residents carried diagnoses, because the Kaufmans held licenses and credentials and professional standing, the families were often persuaded, or worn down, or simply did not know what else to do. The first documented outside sighting of the abuse came in November of 1999. Children riding a school bus looked out the window and saw adult residents of the Kaufman house working naked in the field beside the road. The children reported it. Deputies from Butler County were dispatched and observed the same thing. The Kansas Supreme Court had already ruled that the Kaufman house needed to be licensed as a care facility. The Kaufmans refused. The state struggled to enforce the order. Years passed. By 2004, the Disability Rights Center of Kansas had begun its own independent investigation. They made contact with a resident we will call Barb, a woman who had been living inside the Kaufman house and who, with the help of DRC advocates, was able to escape in May of 2004. Barb's testimony provided federal investigators with exactly what they needed. On October 26, 2004, the FBI executed a search warrant on the Kaufman house. Agents entered and found 6 residents still inside. They also found more than 30 videotapes stored in the Kaufman's bedroom. 30 tapes of everything Arlen had been filming for decades. The evidence was overwhelming. The federal trial took place in the United States District Court in Wichita in November of 2005. The prosecution presented the videotapes. They presented resident testimony. They presented records showing the Kaufmans had billed Medicare and family members for the therapy sessions in which residents were being abused. Arlen Kaufman was convicted on all 31 federal counts. Linda Kaufman was convicted on 30 of 31 counts. The charges included involuntary servitude, forced labor, conspiracy, healthcare fraud, mail fraud, and Medicare fraud. Arlen received 30 years in federal prison. Linda received 7, a sentence that the government immediately appealed as catastrophically insufficient given the severity of the crimes. They were right. In November of 2009, an appellate court resentenced Linda to 15 years. The court found 2 aggravating factors that the original judge had improperly dismissed. The stun gun constituted a dangerous weapon, and the victims were among the most vulnerable human beings imaginable. The Kaufmans appealed in 2008. The 10th Circuit Court of Appeals denied the appeal entirely in a ruling documented as 546 F. 3rd, 1242. In 2020, Arlen Kaufman sought compassionate release from federal prison, citing poor health and the risk of COVID-19. The federal judge who heard that motion was not moved. In his denial, he wrote that he had never had a case where an inmate even claimed, much less proved, treatment by prison officials remotely similar to what the residents of Kaufman House endured. Linda Kaufman received compassionate release in 2016 due to serious illness. She died in 2019, before her sentence was complete. Arlen Kaufman died inside federal prison on January 18, 2021. The victims of Kaufman House, the men and women who were stripped, filmed, shocked, exploited, and gaslit for 2 decades, carry those years with them still. Some of them never fully recovered. Some of them never fully understood what had been done to them. And some of them, finally, had the chance to say it out loud in court, in front of a federal judge, and to watch 2 people who had treated them like property led away in handcuffs. Justice was slow, brutally slow, but it came. If you are watching this and you have a loved one in any kind of residential care facility, any group home, any treatment center, any assisted living situation, document everything. Visit unannounced. Ask questions. And if something feels wrong, trust that feeling. The Kaufman House had 12 complaints filed over 12 years. 12 times someone said something is wrong here. 12 times the system said not quite enough to act. Do not wait for complaint number 13. Sound, a gavel. Fade to low ambient tones. This has been Case 1. Arlen D. Kaufman and Linda J. Kaufman. Newton, Kansas. Convicted by a federal jury in November of 2005. Among the most significant patient abuse convictions in Kansas history. Like this video if these victims deserve justice. Subscribe to Crime Document. And stay right here, because Case 2 is coming, and it happened in a surgical recovery room where patients could not even scream. Case 2, Dennis Clark. Overland Park and Kansas City, Kansas, 1992 through 2017. You have just come out of surgery. Your eyes are half open. You cannot form full sentences. Your body feels like it is wrapped in wet concrete. You trust that the hands touching you are there to help. That is what they told you before you went under. That is what every instinct in your body is telling you, even as the anesthesia wears off and your brain tries to reconnect to reality. And then someone in scrubs is touching you in a way that is not medical. And you cannot move. And you are not sure if this is real or if it is the drugs. And before you can process it, it is over. And a voice says, "Don't worry. You are not going to remember this tomorrow." Dennis Clark said those exact words to a victim. He was wrong. She remembered. And because she remembered, and because she was brave enough to report it, and because other women were brave enough to come forward, Dennis Clark eventually faced a courtroom. Though it took years of institutional failure and 2 separate hospitals to get there. Clark was a registered nurse who specialized in post-anesthesia care, the period immediately after surgery when patients are emerging from sedation. It is one of the most sensitive and intimate environments in all of medicine. Patients in the PACU, the post-anesthesia care unit, are profoundly disoriented. They are in pain. They are confused. They cannot coordinate their bodies. They cannot shout for help. They cannot, in many cases, even be sure their memories of the experience are reliable, because anesthesia creates gaps in consciousness that patients later struggle to fill. Clark knew this. He exploited it deliberately and systematically. Clark was hired at Menorah Medical Center in Overland Park, Kansas, in February of 2010. His background check cleared. He began working in surgical recovery. Within months, patients were reporting assaults. In May of 2010 and again in June of 2011, Clark targeted female patients recovering from surgical procedures. He told one victim coming out of sedation that he needed to check her gag reflex. That was the excuse he used to force a sexual act upon her. Another victim testified that while she was exhausted, disoriented, and a little confused following surgery, Clark began sexually assaulting her. Both incidents were reported to law enforcement. Both resulted in police investigations. Both investigations were closed without charges being filed because, according to investigators, the allegations could not be substantiated. The victims were believed to have been too disoriented, too uncertain of their own memories, too compromised by the anesthesia to provide testimony that could sustain a criminal case. The hospital terminated Dennis Clark in February of 2012, but they made a catastrophic choice. Rather than report him to law enforcement or state licensing authorities in a way that would follow him, they simply designated him ineligible for rehire in their own internal system and sent him on his way. He walked out of Menorah Medical Center and, within 2 years, was working in a PACU again. Clark obtained employment at Providence Medical Center in Kansas City, Kansas. How? By doing what predators do when institutions fail to communicate with each other. He applied for the job, listed references, passed whatever checks Providence ran, and began working around sedated patients again. Between December of 2013 and May of 2014, Clark assaulted at least 4 women at Providence. The details of what he did became public during court proceedings, and they are deeply disturbing. One victim recounted Clark loading her into a wheelchair after surgery, taking her into a bathroom, closing the door, and using the wheelchair to block it from the inside. He stripped her, told her he needed to inspect her surgical incisions, bent her forward, and sexually assaulted her from behind. The assault was interrupted by a charge nurse who opened the door and screamed, "What are you doing?" Clark fled the bathroom. Another victim lay recovering from surgery when Clark stroked her hair and told her not to worry, that she would not remember any of this tomorrow. He was wrong about that too. The May 2014 assault of a 22-year-old patient finally triggered a full criminal investigation. 2 more women came forward. Wyandotte County prosecutors filed 4 counts of aggravated sexual battery in October of 2014. And then, finally, Overland Park Police reopened their previously closed Menorah investigations with fresh eyes and fresh urgency. Johnson County filed 7 charges, 2 counts of aggravated criminal sodomy, 2 counts of aggravated sexual battery, and 3 counts of lewd and lascivious behavior. The latter category arose from complaints by neighbors in Gardner, Kansas, who reported Clark had been exposing himself and masturbating in their presence, suggesting the crimes at the hospital were not the whole picture of who Dennis Clark was. Clark dragged out the legal process for years. He backed out of plea agreements multiple times, extending the ordeal for his victims, who had to remain ready to testify, had to relive their experiences in preparation for trials that kept getting delayed. It was November of 2017, more than 3 years after the last known assault, before Clark finally entered a plea of no contest in Johnson County to 1 count of aggravated criminal sodomy. 6 other Johnson County charges and the Gardner misdemeanors were dismissed as part of the agreement. On January 5, 2018, Johnson County District Judge Thomas Sutherland sentenced Dennis Clark to 155 months in prison, approximately 13 years. The judge's words at sentencing were unsparing. Reprehensible just doesn't seem quite adequate to describe that you took advantage of victims at a time when they trusted you, at a time when they were most vulnerable, in a location where they probably did and should have felt safe, and you violated that trust. Victim Erica Zamora spoke publicly about the sentencing. She told reporters, "Closure, a sense of closure. This little piece of closure that I've gotten today has lifted the world off of my shoulders. Clark was transferred to El Dorado Correctional Facility in Kansas on January 23, 2018. But the criminal process was not over. Wyandotte County had its own charges pending from the Providence assaults. Clark's first trial there ended in November of 2019 with an acquittal on one count and a hung jury on the remaining charges. A bitter outcome for victims who had already waited years. A retrial was delayed by the COVID-19 pandemic. When it finally proceeded, Clark was convicted. He appealed. The Kansas Court of Appeals affirmed the trial court ruling denying his motion to dismiss on February 4, 2022, in a decision documented as State v. Clark, number 123,904. His nursing license was revoked. But here is the part that should haunt every person who believes healthcare systems protect patients. Dennis Clark was investigated for sexual assault at Menorah Medical Center twice before his employment was terminated. He was never reported to the state licensing board in a way that prevented him from obtaining new clinical employment. He walked into Providence Medical Center and found 4 more victims within 18 months. 2 hospitals, 2 investigations, at least 6 confirmed assault victims, likely more who never came forward. The system that was supposed to track dangerous practitioners failed. And women paid for that failure with their safety, their dignity, and years of their lives spent fighting to be believed. They were believed, eventually, but it cost too much to get there. Sound, a door closing, low musical sting. This has been Case 2. Dennis Clark, former registered nurse, convicted in both Johnson County and Wyandotte County, Kansas, sentenced to more than 13 years in federal prison. His Kansas nursing license permanently revoked. Hit that subscribe button for Crime Document. And when you come back from the break, Case 3 is one of the most chilling cases of mass patient infection in American healthcare history, and it reached directly into Hays, Kansas. Case 3, David Michael Kwiatkowski. Hays, Kansas, 2010, The Traveling Infector. The name is David Michael Kwiatkowski. He was not a nurse. His title was Cardiac Catheterization Laboratory Technician. But he worked alongside nurses and physicians in the most vulnerable clinical environments imaginable, and what he did to patients in Hays, Kansas, and across multiple states, resulted in one of the harshest sentences ever handed down for healthcare-related patient harm in American history. 39 years in federal prison. For a man who never held a scalpel, never prescribed a medication, never administered a lethal injection. He used a syringe, and fentanyl, and his own infected blood. Here's how it worked. Kwiatkowski worked in cardiac catheterization labs, the clinical suites where doctors thread thin tubes into patients' blood vessels to diagnose and treat heart disease. These procedures require sedation and pain management, and the sedation of choice was typically fentanyl, a synthetic opioid more powerful than morphine. Fentanyl was drawn up into syringes and kept in the lab, ready for administration. Kwiatkowski would take a fentanyl syringe, inject himself with the contents, then refill the now contaminated syringe with saline solution and return it to the sterile field, where it would be administered to the next patient scheduled for the procedure. The saline syringe meant the patient received no pain relief during their cardiac catheterization, an already uncomfortable and invasive procedure. But more terrifyingly, it also meant the patient was injected with Kwiatkowski's blood that was infected with the hepatitis C virus. Hepatitis C is a bloodborne disease that damages the liver over time, leading to cirrhosis, liver failure, and death. It is manageable with modern treatment, but not without permanent consequences. And in 2010, treatment options were significantly more limited than they are today. Kwiatkowski had been infected with hepatitis C. He knew it. A physician at Hays Medical Center in Hays, Kansas, a small city of approximately 20,000 residents in Ellis County, informed him of this fact around May of 2010. Kwiatkowski later admitted, in federal court, that he had swapped syringes at least 20 times after receiving that diagnosis. He knew he was infected. He kept going. 6 patients at Hays Medical Center were confirmed infected with Kwiatkowski's genetically matched strain of hepatitis C. Genetic analysis, the same technology used to solve cold cases through DNA matching, was used to trace the infections definitively back to a single source, Kwiatkowski's blood. Among the victims was a woman named Eleanor Murphy from Hays, Kansas. She underwent cardiac catheterizations on June 7th and July 12th of 2010. She contracted hepatitis C from those procedures. A medical examiner later determined that hepatitis C had contributed to her death. Eleanor Murphy is a victim of homicide, not of a weapon anyone can hold in their hand, but of deliberate, knowing, and callous indifference to whether she lived or died. Another Kansas victim, 71-year-old Linda Ficken of Andover, was infected during a cardiac catheterization. She later recalled Kwiatkowski standing at her bedside for more than an hour after the procedure, pressing on the catheter entry site. She did not know what he had done. She trusted him completely. Before Hayes Medical Center, Kwiatkowski had been fired from at least 4 other hospitals. Arizona Heart Hospital found him passed out in a men's room with a syringe floating in the toilet water. He was let go. He found another job. This was possible because medical technicians, unlike nurses and physicians, were not tracked in any national misconduct database. There was no centralized system to follow someone like Kwiatkowski from state to state, from hospital to hospital. Each institution ran its own background check. Each institution saw a qualified technician with references, not a drug addict who had been removed from 4 prior workplaces for dangerous behavior. After Hayes Medical Center, Kwiatkowski moved to New Hampshire. He began working at Exeter Hospital in April of 2011. Within months, a cluster of unexplained hepatitis C cases emerged among patients who had no other known risk factors. Investigators were baffled. Standard epidemiological analysis could not explain the pattern, and then someone thought to test the healthcare workers. Kwiatkowski's genetic strain of hepatitis C matched every single one. He was arrested on July 19, 2012. Federal charges were filed in multiple districts, including the District of Kansas, which filed 2 counts related to the harm caused to Kansas victims, including Eleanor Murphy's death. Prosecutors in New Hampshire led the overall case. On August 13, 2013, Kwiatkowski entered a guilty plea to the federal charges. He admitted that he had obtained fentanyl by fraud, that he had tampered with syringes, and that he had done so knowing he was infected with a communicable disease. In total, 46 patients across 4 states were confirmed infected with his strain of hepatitis C. Sentencing took place on December 2, 2013 in Concord, New Hampshire. Kansas victims made the journey. Ronnie Murphy, son of Eleanor Murphy, stood before the court and wept. He told the judge, "I cannot forget, nor can I offer forgiveness for what he has done. His path and my mother's path never should have crossed." Linda Ficken looked directly at Kwiatkowski and said, "On one hand, you were saving my life, and on the other hand, your acts are a death sentence for me." A Vietnam veteran named Linwood Nelson, 66 years old at the time of sentencing, told the court he could no longer work as a contractor for fear of accidentally cutting himself and infecting other people. He had distanced himself from his grandchildren. He had served his country in combat, and never imagined that the greatest physical threat of his life would come from a man in a white coat, not knowing it was going to be friendly fire that would injure me. Judge Joseph LaPlante sentenced David Kwiatkowski to 39 years in federal prison. It was, at the time, believed to be the harshest sentence ever handed down for this category of healthcare-related crime in the United States. The Kansas victim sentenced was filed as part of 2 federal counts in the District of Kansas and was referenced in the U.S. Attorney's Office press release from the District of Kansas confirming Kwiatkowski's sentence in connection with the widespread hepatitis C outbreak. The case prompted New Hampshire to create the first board of registration for medical technicians in the nation, a registry designed to track non-nursing clinical workers who move between hospitals the way Kwiatkowski did, leaving infected patients in their wake. No other state followed New Hampshire's lead immediately. The gap in the national system that Kwiatkowski exploited continued to exist long after his sentencing. Hayes Medical Center, a community hospital serving rural western Kansas, spent years helping infected patients access treatment. Support groups formed. The city of Hayes, which had nothing to do with Kwiatkowski's hiring decisions, bore the weight of a healthcare scandal that had nothing to do with the quality of its community and everything to do with the failure of a national credentialing system that let a known drug addict with a deadly bloodborne disease keep working with cardiac patients. A decade after the outbreak, reporting by the Hayes Post noted that a medical registry established to help track exposed patients was under threat of being discontinued due to funding challenges, raising concerns from Hayes victims who feared they were already being forgotten. They should not be forgotten. Eleanor Murphy deserves to be remembered. Linda Ficken deserves to be remembered. Linwood Nelson and every other patient who went in for a routine cardiac procedure and came out with a life-altering, potentially life-ending diagnosis. They deserve to be remembered. And they deserve to know that the man responsible for what happened to them will spend decades behind bars. The U.S. Department of Justice, District of Kansas, confirmed the sentence in an official press release titled, "Former hospital employee sentenced in connection with widespread hepatitis C outbreak." This has been Case 3. David Michael Kwiatkowski, cardiac catheterization lab technician, pled guilty to federal charges in the District of Kansas and New Hampshire. Sentenced to 39 years in federal prison on December 2, 2013. His crimes reached Kansas in 2010 and killed at least one Hayes resident. Comment below. Were you aware that medical technicians had no national misconduct registry when this happened? Because that system failure is part of this story too. We are back after this. And Case 4 takes us to an Andover nursing home, where an entire night shift knew what was happening and said nothing. Case 4. Jeffrey Nyangwiso and the Victoria Falls Nursing Home Scandal. Andover, Kansas, 2013 through 2014. The name is Jeffrey Nyangwiso. But the story of Victoria Falls Skilled Nursing Home in Andover, Kansas, is bigger than one person. It is the story of what happens when a culture of abuse takes root inside a care facility, when silence becomes standard, and when the people who are supposed to protect the most vulnerable among us instead become the threat they were hired to prevent. And it was caught on camera. Andover is a suburban city in Butler County, immediately east of Wichita. It is a growing, comfortable community, the kind of place families move to for good schools and quiet streets. And it is the kind of place where families also place aging parents in care facilities they believe, with every reasonable expectation, will honor the dignity of their loved ones. One family had reason to believe their mother was not being honored. They did not know exactly what was happening, but something felt wrong. So they did what more and more families across America were quietly beginning to do. They installed a hidden camera in their mother's room. The camera recorded footage on September 2, 2013. The time was between 2 in the morning and 3 in the morning, the deep of the night shift, when administrators were home, when management was absent, when the only people in the building were the patients and whoever was supposed to be watching over them. What the camera captured was this. A worker approached the room of Donna Culture. Donna Culture was a stroke victim with severe dementia. She was in her wheelchair. Her wheelchair, the seat she depended on to maintain any degree of mobility and dignity. The worker reached for Donna Culture and dragged her from that wheelchair. Not helped her, not gently assisted her, dragged her. Donna Culture went from her wheelchair to the floor, dropped directly onto the linoleum in the darkness. And then the worker left. Donna Culture lay on the floor of her room for nearly 45 minutes. She called out. She pleaded for help. At one point, someone returned, not to lift her, not to help her, but to throw a neck pillow in her direction. And then left again. 45 minutes on a cold floor. A stroke victim. A woman with dementia who could not fully understand why she had been put there, who could not call for help in any way that would summon rescue, who lay in the dark of a care facility that her family was paying to keep her safe. The family took the footage to the Andover Police Department on November 3, 2013, approximately 2 months after the incident was recorded. The delay speaks to the weight of what they had seen, the difficulty of processing it, and perhaps the fear of what would happen next. What happened next was that authorities viewed the footage and immediately launched an investigation. Jeffrey Nyangwiso, 40 years old at the time of his arrest, was identified as the worker seen in the footage. He was charged with felony elder abuse, a charge carrying a potential sentence of up to 11 years in prison and fines in excess of $100,000. He entered a plea of not guilty, and the case moved through the Kansas court system. But the investigation did not stop with Nyangwiso. Because the Kansas Department for Aging and Disability Services, KDADS, launched a sweeping facility-wide inspection that began in January of 2014 and revealed something far more alarming than one person's crime on one night. At least 63 residents of Victoria Falls skilled nursing home had been physically or verbally abused by staff members. 63 confirmed victims. One resident alone had been targeted by at least 4 separate staff members. The inspection resulted in a 150-page report documenting systematic failures across virtually every category of patient protection. Failure to prevent abuse, failure to maintain appropriate standards of care, failure to maintain accurate medical records, inadequate staffing, insufficient background checks on employees, failure to investigate abuse allegations when raised internally, and consistent failure to maintain the basic dignity of the residents entrusted to the facilities. Care. Staff members told investigators, during the course of the inspection, that the entire night shift was aware of what was happening to residents. They knew. Multiple employees knew about the abuse, knew it was ongoing, knew it was wrong, and said nothing. The reason they gave? They did not report it because they believed nothing would be done. That belief, in itself, tells you everything about the culture that had taken root at Victoria Falls. This was not a facility where abuse was a secret. It was a facility where abuse was normalized, where the night shift had reached a collective, unspoken understanding that the rules did not apply between 2 and 3 in the morning, that the people in those beds and those wheelchairs were not worth the effort of treating with dignity, and that no one in authority would care enough to find out. They were wrong about that last part, but it took a hidden camera to prove it. Nurse Jacqueline Laware, an RN employed by the facility, was identified during the investigation as having knowledge of abuse and failing to report it. In Kansas, as in most states, licensed nurses are mandatory reporters. They are legally required to report suspected abuse of vulnerable adults to authorities. Failure to report is itself a violation, both criminal and professional. Laware was referred to the Kansas State Board of Nursing for potential license revocation proceedings. The facility's owners, Dennis and Debbie Bush, operating through an entity called Watercrest Communities, were held financially accountable by the Federal Centers for Medicare and Medicaid Services. CMS levied fines that investigators believe to be the largest ever imposed on a Kansas nursing home at the time, at least $155,800, with total financial exposure reaching approximately $200,000. The fines represented the regulatory system acknowledging the severity of what had occurred, but to the families of 63 victims, no fine captures what their loved ones experienced. The Victoria Falls case prompted conversations across Kansas about nursing home oversight, hidden cameras, and the rights of families to monitor care for their relatives. At the time, Kansas had no clear legal framework governing the use of surveillance cameras in nursing home rooms, a gap that advocates began pushing to address in the wake of this case. The footage of Donna Culture being dragged from her wheelchair and left on the floor for 45 minutes became, in many ways, the defining image of this scandal. Not because it was the worst single act documented in the investigation, but because it was the one that was visible. 63 victims' worth of abuse happened in the dark, witnessed only by the abusers and the abused. Donna Culture's ordeal was witnessed by a camera, and because of that camera, the world eventually saw. Every person in this documentary was vulnerable. But there is something particularly devastating about the vulnerability of elderly people with dementia who cannot advocate for themselves, who may not fully understand what is being done to them, who rely entirely on the decency and professionalism of the people in whose care they have been placed. Victoria Falls failed them. Every single one of them. This has been Case 4. Jeffrey Nyangwiso and the Victoria Falls Skilled Nursing Home Abuse Scandal. Andover, Kansas. Felony elder abuse charges filed 2013. 63 confirmed victims. Kansas Nursing Board referral for registered nurse Jacqueline Laware. Federal fines of approximately $200,000 levied against the facility. If this video is helping you understand how vulnerable people get hurt in care facilities, share it. Hit subscribe on Crime Document. And stay right here, because Case 5 is about a Kansas nurse who drugged a dementia patient to sleep so the night shift would not be bothered. And she thought she deserved a thank you. Case 5, Jennifer Lynn Rivas. Lansing, Kansas, May 2019, the night shift drug. Case 5. The name is Jennifer Lynn Rivas. And the first thing she did after what she did was take a photograph and send it to a coworker. Think about that. Not guilt. Not panic. not the frantic attempt to cover tracks that characterizes most criminal behavior in moments of exposure. No. Jennifer Lynn Rivas administered an unauthorized medication cocktail to an elderly woman with severe dementia, watched that woman's head loll forward, slumped in her wheelchair, and then took out her phone and texted the incoming shift nurse a picture. The caption she typed read, "You're welcome. I hope she is asleep most of the day tomorrow." Then she typed, hint hint. She thought she had done something clever. She thought the night shift would appreciate it. She thought she deserved, in her own words that emerged later in this investigation, a thank you. Jennifer Rivas was 37 years old. She worked as a registered nurse at Twin Oaks Health and Rehab Center in Lansing, Kansas, a care facility in Leavenworth County in the northeastern part of the state, between Kansas City and Topeka. In May of 2019, facility administrators discovered that an elderly resident with severe dementia had been given her evening and bedtime medications simultaneously, not staggered as prescribed, not administered according to the care plan developed by her physicians, but given all at once in a single administration. That discovery, troubling on its own, became significantly more alarming when investigators noted that in addition to the scheduled medications, the resident had also been given two drugs that were not part of her care plan at all, Ativan and Benadryl. Ativan is the brand name for lorazepam, a controlled benzodiazepine used to treat anxiety and seizures. Benadryl is diphenhydramine, an antihistamine with sedative properties. Neither was prescribed for this patient. Neither should have been anywhere near her medication cup. Both of them caused drowsiness. Heavy, deep, disorienting drowsiness, especially in elderly patients with compromised neurological function, especially in patients whose baseline level of cognitive awareness is already significantly diminished by dementia. Combined with her already prescribed evening medications, the effect on this woman would have been profound. Jennifer Rivas was identified as the nurse who had been responsible for the patient's care during the relevant hours. When confronted, she admitted it. She admitted administering the unauthorized drugs. She admitted sending the text message. And she explained, or attempted to explain, why. The resident had been what Rivas described as exit-seeking. Exit-seeking is a behavioral pattern common in dementia patients. They become agitated, try to leave the facility, walk toward exits repeatedly, and can be extremely difficult to redirect. Exit-seeking behavior is emotionally and physically exhausting to manage, particularly during overnight shifts when staffing is lean and cognitive demands on caregivers are high. Rivas decided the solution was chemical sedation, not the behavioral redirection techniques she had been trained in, not calling a physician to ask for an assessment and possibly a legitimate prescription for anxiety management, not consulting a supervisor. Chemical sedation, unauthorized, administered without a physician's order, without any clinical basis, documented nowhere in the patient's medical records, because it was not supposed to be there. After the woman received Rivas's unauthorized cocktail, she began vomiting. She became severely lethargic, far beyond the ordinary drowsiness of a nighttime medication cycle. She had to be transferred to a hospital for emergency care. The text message Rivas sent to her colleague, the one with the photograph of the woman slumped in her wheelchair, was discovered during the investigation. It is a remarkable artifact of a particular kind of wrongdoing, the kind committed not in secret darkness, but in the casual confidence of someone who has convinced herself that what she did was reasonable, maybe even helpful. Who else would be up at that hour dealing with this? Who else would understand? The incoming nurse who received that text was the one who reported it. Leavenworth County prosecutors charged Rivas with endangerment of a vulnerable adult, unlawful administration of a controlled substance, and battery, all misdemeanor charges. The decision to prosecute at the misdemeanor rather than felony level was disputed by advocates who felt it did not adequately reflect the potential harm caused to the victim. A sedated elderly woman with dementia who is vomiting and severely lethargic is in genuine medical danger. Had the incoming nurse not found her in that state and escalated immediately, the outcome could have been significantly worse. On September 17, 2021, Jennifer Lynn Rivas appeared in Leavenworth County District Court and entered a plea of no contest. She was sentenced to 1 year of probation. No jail time, no prison. 1 year of probation, during which she was required to comply with standard conditions and avoid further criminal conduct. Leavenworth County Attorney Todd Thompson commented on the case publicly, saying, "After a lifetime of bettering our community, our senior generation deserves to be treated with dignity and respect." He is right. They do. What is missing from that statement is an acknowledgement of how fundamentally the system failed this resident. 1 year of probation for drugging a vulnerable elderly woman, hospitalizing her with vomiting and severe sedation, and then texting a photograph of her slumped body to a colleague as if it were something to celebrate. 1 year of probation and the word misdemeanor attached to it. The woman who received that unauthorized medication did not get 1 year of anything. She had her bodily autonomy violated by someone who was legally and professionally responsible for protecting it. She was hospitalized. She was frightened, to whatever degree her cognition allowed her to process fear. And somewhere in a nursing home in Leavenworth County, she never knew who had done it or why. Jennifer Rivas's nursing license was subject to review by the Kansas State Board of Nursing in the wake of the criminal proceedings. The text message she sent, a photograph of a sedated victim with the caption, "You're welcome," became evidence in that administrative process. She said she deserved a thank you. The criminal justice system gave her 1 year of probation. The woman in that wheelchair deserved better. Every resident in every nursing home in this country deserves better. And every nurse who believes that a quiet night shift is worth more than a patient's safety deserves to find out exactly what happens when a coworker has a conscience and a phone, and the courage to use both. This has been Case 5. Jennifer Lynn Rivas, registered nurse, Lansing, Kansas, pled no contest September 17, 2021. Sentenced to 1 year of probation for unauthorized medication administration on a vulnerable elderly patient with severe dementia. We are about to get into the fentanyl cases, and there are several of them. Case 6 is a nurse who stole fentanyl from patients at 4 Kansas hospitals and may have contributed to a patient's death. Stay with Crime Doc. Case 6, Julie Lynn Grant, Overland Park, Kansas, 2015 through 2019, the 4-hospital fentanyl thief. The name is Julie Lynn Grant. And if you have ever had surgery in the Kansas City metropolitan area between 2015 and 2019, what you are about to hear will make you never look at an 4-bag the same way again. Grant was 50 years old when she was arrested. She had worked as a registered nurse in surgical and critical care settings for long enough to know exactly how controlled substances move through a hospital. She knew the dispensing cabinets. She knew the verification systems. She knew the tamper-evident packaging and when it could be defeated. She knew when pharmacists were busy and when clinical staff was distracted. And she used every piece of that knowledge to steal fentanyl from patients who needed it, replacing it with something that would not ease their pain, would not sedate them through procedures, would not do anything at all. She replaced it with water. Fentanyl is a synthetic opioid approximately 100 times more potent than morphine by weight. It is used in surgery for pain management and sedation. When a patient is scheduled to receive a fentanyl 4 infusion and that infusion has been tampered with, when the bag has been pierced, the drug extracted, and the bag refilled with plain water, the patient receiving it gets nothing. They feel everything, and they do not know why. The investigation that led to Julie Grant's arrest began on April 4, 2019, while she was working at HCA Midwest Research Medical Center in Kansas City, Missouri. On that date, she ordered a compounded fentanyl 4-bag using another nurse's credentials, meaning she logged in under someone else's name to place the order, a classic drug diversion tactic designed to obscure the trail. A hospital pharmacist grew suspicious of the order and flagged it for investigation. What investigators found when they examined the bag was the evidence they needed. The bag had been tampered with. Fentanyl had been extracted. The bag had been refilled. Analysis confirmed that what remained in the bag was not the controlled substance that should have been there. On that same day, April 4, 2019, a patient who had received a potentially tampered bag died. The death was investigated. No murder charges were filed in connection with it, but the timeline placed the patient's death and the tampered bag in proximity that investigators documented carefully. Grant's hair was tested for controlled substances. It came back positive for fentanyl and hydrocodone. The drug was in her system. She had been using it, and the pattern of her behavior across multiple hospitals established that this had been going on for years. Investigation reconstructed her employment history. Grant had exhibited suspicious behavior involving controlled substances at 4 prior institutions in the Kansas City area. HCA Overland Park Regional Medical Center in Overland Park, Kansas. Advent Health Shawnee Mission in Merriam, Kansas. St. Joseph Medical Center in Kansas City. Each of these institutions had documented concerns. None of them had resulted in criminal charges. None of them had been reported in a way that prevented Grant from obtaining new employment. After being terminated from HCA Midwest Research Medical Center following the April 2019 investigation, Grant applied for a nursing position at Olathe Medical Center in Olathe, Kansas. On her application, she omitted her prior employers. She was hired. Within weeks, Olathe Medical Center's own pharmacy surveillance identified suspicious activity involving controlled substances and Grant's access logs. She was flagged, investigated, and terminated again. Federal investigators, working with the Drug Enforcement Administration and the FDA's Office of Criminal Investigations, pieced together the full picture. Grant was charged with obtaining a controlled substance by fraud, a federal offense. She entered a guilty plea. At the time of her plea, prosecutors noted she faced up to 4 years in federal prison. The case against Julie Grant illustrates a systemic vulnerability that appears repeatedly in the drug diversion cases examined throughout this documentary. Hospitals have medication dispensing cabinets with electronic access controls, but the controls only catch what they are programmed to catch. A nurse who knows the system can defeat it, particularly by using other staff members' credentials, by manipulating the counting process for controlled substances, or by accessing override functions designed for emergencies. Once a nurse is inside those systems, the audit trail may not surface for weeks or months, and in that time, patients receive water instead of pain medication. The physical harm to patients who receive water instead of fentanyl during surgical and critical care procedures is real and documented. Post-surgical patients who do not receive adequate pain management are at risk for a cascade of complications: elevated blood pressure, increased heart rate, stress hormonal responses, difficulty breathing, impaired wound healing, and, in vulnerable patients, cardiovascular events. A 70-year-old recovering from cardiac bypass surgery who receives a saline solution instead of the fentanyl that was supposed to be in there is not merely uncomfortable. They are in danger. Julie Grant worked in the exact clinical environments where these risks are most acute. And she did it across at least 4 institutions over multiple years, each time escaping with a termination rather than an arrest, and each time finding a new hospital willing to hire her without full knowledge of what had happened at the previous one. The information-sharing failure that allowed Dennis Clark to move from Menorah to Providence, and that allowed David Kwiatkowski to move from hospital to hospital, appeared here too, in a different form. Clinical nurses, unlike some categories of medical professionals, may not always be tracked in a centralized database that flags terminations for cause related to controlled substance violations. Individual state nursing boards may be notified, but timelines vary, and in the gap between a hospital's termination decision and a nursing board's disciplinary action, a nurse can obtain new employment. The FDA, in its public records on this case, identified the investigation as a joint effort between FDA's Office of Criminal Investigations, the DEA, the Department of Health and Human Services Office of Inspector General, and the FBI Kansas City Field Office. The breadth of the investigative team reflects how seriously federal authorities take drug diversion in healthcare settings, not only as a criminal matter, but as a patient safety crisis. For hospitals, multiple victims, at least 1 death on the date of a confirmed tampering, and a federal charge that carried a maximum of 4 years. For stealing medication from patients who needed it, potentially causing or contributing to a death, and doing it repeatedly across multiple institutions over multiple years. Every surgery patient who trusts that the four going into their arm contains what the bag says it contains, they are trusting a system, and that system is only as reliable as the people inside it. Sound, the hum of an N4 pump, the click of a cabinet locking. This has been Case 6. Julie Lynn Grant, registered nurse, Overland Park, Kansas, charged federally with obtaining a controlled substance by fraud. Multiple hospitals affected across the Kansas City metro area. Federal plea entered 2019. Coming up next, Case 7. Another fentanyl theft. Another Kansas hospital. but this one has a detail so specific it will make your stomach drop. Case 7. Faith Nacarado and Alec Ramirez. Overland Park and Merriam, Kansas, 2020 through 2021. 2 names. 2 nurses. 2 separate cases filed by the United States Attorney's Office for the District of Kansas. Both sentenced on the same day, March 13, 2023, both involving fentanyl theft from Kansas City area hospitals. Both cases documented by the U.S. Department of Justice and the Drug Enforcement Administration. These cases are presented together because they represent the most documented cluster of drug diversion prosecutions in Kansas history, a pattern that the U.S. Attorney's Office for the District of Kansas openly acknowledged was growing. That was a crisis reaching inside the state's medical facilities, and that was affecting real patients who had no idea their pain management had been compromised. First, Faith Nacarado. Nacarado was 42 years old when federal investigators built the case against her. She had been working simultaneously at 2 Kansas hospitals, Menorah Medical Center in Overland Park and Advent Health Shawnee Mission in Merriam, both in the greater Kansas City metro area of Johnson County. Between January and April of 2020, she was stealing fentanyl from both. The method was the same method documented in the Grant case. She accessed fentanyl vials through the hospital's dispensing systems, extracted the controlled substance, and replaced the contents of the vials with saline solution. The vials, now containing saline instead of fentanyl, were returned to the medication supply chain where they would eventually be administered to patients. Saline. Into patients who were scheduled to receive fentanyl for pain management. Nacarado was charged with obtaining a controlled substance by fraud. She entered a guilty plea. On March 29, 2023, she was sentenced in federal court to 12 months and 1 day in federal prison. The additional 1 day past the 1-year mark is legally significant. It ensures the sentence is classified as a federal conviction rather than a misdemeanor equivalent, affecting eligibility for early release and other post-conviction considerations. Her nursing license was subject to Kansas State Board of Nursing proceedings following the federal conviction. Second, Alec Ramirez. Ramirez was 32 years old at the time of his federal sentencing. He had been working at Menorah Medical Center in Overland Park, the same facility where Nacarado also stole drugs, and the same facility where Dennis Clark had been investigated twice before moving on to Providence Medical Center. Menorah Medical Center appears multiple times in the Kansas healthcare crime record, not because of any institutional malice, but because it is one of the largest and busiest surgical facilities in the region, with a correspondingly large pharmacy operation and a correspondingly large exposure to the national drug diversion crisis. Ramirez stole 46 vials of fentanyl and 42 vials of hydromorphone from Menorah Medical Center in March of 2021. 46 vials of fentanyl, 42 vials of hydromorphone. Hydromorphone is another powerful opioid, brand name Dilaudid, used for severe pain management in hospital settings. He replaced the contents of the stolen vials with sterile water. 46 patients expecting fentanyl, 42 patients expecting hydromorphone, 88 doses of pain medication that were actually sterile water. Ramirez was approached by police in August of 2021 and admitted the theft and substitution scheme during the interview. He was charged federally. He pleaded guilty. On March 13, 2023, the same date as Nacarado's sentencing, Ramirez was sentenced to 18 months in federal prison. He also surrendered his Kansas nursing license as part of the sentencing agreement. The U.S. Attorney for the District of Kansas issued a public statement in connection with these sentencings that deserves to be heard. Our medical facilities are not immune from the effects of the growing fentanyl addiction crisis in our country, and as a result, the District of Kansas prosecutes a growing number of cases against healthcare providers accused of stealing medication intended to go to patients. That statement is notable for what it acknowledges. These are not isolated bad actors. There is a growing pattern. The cases being prosecuted represent a larger problem in healthcare systems across the country, and Kansas is not immune to it. The combined picture of the Kansas drug diversion cases, Grant, Nacarado, and Ramirez, reveals a troubling reality about modern hospital medication management. Dispensing cabinets with electronic access controls, fingerprint scanners, controlled substance logging and counting protocols. All of these measures exist. All of them have documented vulnerabilities that determined staff members can exploit. And when they are exploited, patients pay the price in pain and in risk. The 88 patients at Menorah who received sterile water instead of fentanyl or hydromorphone from Ramirez's tampered vials. How many of them told their nurses, during their recoveries, that their pain medication didn't seem to be working? How many of them were told to try to relax, that the medication just needed time to kick in? How many of them went home from their hospitalizations carrying the memory of unnecessary pain, never knowing what had actually happened? Hospitals are required to report drug diversion events to the DEA and to state authorities. But the patients themselves, the ones whose medication was stolen, may never be individually notified. The disclosure protocols vary by state and by institution. In Kansas, as in most of the country, a patient who unknowingly received a saline substitute for their pain medication may have no way of knowing it ever happened. That gap between institutional accountability and individual patient knowledge is one of the quieter injustices embedded in the drug diversion crisis. The nurses face federal charges. The hospitals pay regulatory fines. The dispensing systems get updated. And the patients who received water instead of fentanyl go home and never know they have a piece of this story too. Sound, a dispensing cabinet beeping. A fingerprint scanner declining access. Silence. This has been Case 7. Faith Nacarado and Alec Ramirez. Registered nurses. Johnson County, Kansas. Both sentenced March 13, 2023 in federal court. Nacarado to 12 months and 1 day. Ramirez to 18 months. Fentanyl and hydromorphone stolen from Johnson County hospitals and replaced with saline and sterile water. 88 doses. 88 patients. Do not leave this video yet, because Case 8 is the one that will test you the most. A school nurse. Children as young as 2 years old. And a life sentence handed down in Manhattan, Kansas. Case 8. Joshua Penabaz. Manhattan, Kansas, 2009 through 2021, the preschool predator. And before we go further, if you are watching this with children nearby, this case involves the sexual abuse of children as young as 2 years old. The details we discuss are documented in court records from Riley County, Kansas, and in reporting by multiple verified Kansas news outlets. We present these facts because they are documented, because the victims deserve acknowledgement, and because silence on cases like this allows them to happen again. Penabaz was a nurse. He was employed as the school nurse at College Hill Early Learning Center, a preschool that operated within the Manhattan-Ogden Unified School District 383 in Manhattan, Kansas. Riley County, home of Kansas State University, a college town of approximately 55,000 residents, known for the Manhattan Arts Center, the Flint Hills landscape, and Fort Riley military base next door. It is not the kind of place anyone thinks of when they think of the worst crimes imaginable. And yet, Manhattan, Kansas is where Joshua Penabaz had access to small children in a position of medical authority for more than a decade. He was arrested on February 18, 2022, and placed on a $1 million bond. $1 million, a bond figure that signals the severity with which Riley County authorities viewed the allegations they were prepared to file. And the allegations were severe. The original charges numbered 27 counts. 11 of those counts were rape. The remaining charges included aggravated indecent liberties with a child and aggravated criminal sodomy. The crimes were alleged to have occurred over a span of 12 years, from 2009 through 2021. 12 years. The entirety of this period while Penabaz continued to hold nursing employment, continued to hold his medical license, continued to work with children. The victims ranged in age from 2 to 5 years old. At least one victim was a student at College Hill Early Learning Center, a child he had access to through his position as the school's nurse. Other victims, aged 2 to 4, were children he knew through other avenues unconnected to his school employment. They are identified in court records as victims of sexual assault. Children who could not understand what was happening to them. Children who did not have the language to fully describe what had been done to them, and who would spend years in therapeutic environments learning to process experiences that no child should ever have. The number and diversity of victims, spanning from preschool-age students to toddlers he knew outside of school, indicates that Penabaz was not opportunistically exploiting a single access point. He was a predator who constructed his life around access to small children. The school nursing position was one such access point. But it was not the only one. Riley County prosecutors and the Kansas Bureau of Investigation conducted the investigation following the initial arrest. Additional charges were filed as the investigation expanded. In one instance, an additional rape charge involving a preschool student was added to the docket after investigators identified a further victim. In April of 2023, rather than proceed to trial on all 27 original counts, Joshua Painabaz entered a guilty plea to 2 counts of aggravated indecent liberties with a child. These 2 counts were filed under what Kansas law calls Jessica's Law, a statutory framework named after a Florida child murder victim that mandates minimum sentences for the most serious sex offenses against children under the age of 14. Under Jessica's Law, the minimum sentence for aggravated indecent liberties with a child is 25 years in prison. There is no discretion below that floor. The legislature set it there deliberately, in recognition that crimes against children of this severity cause harm that cannot be adequately addressed by shorter incarceration. Sentencing was scheduled for July 6, 2023. Before Judge David Kawai of the Riley County District Court, Painabaz's defense attorney filed a motion requesting a departure from the mandatory minimum, arguing that 12.5 years would be adequate given the facts of the case. Judge Kawai rejected the departure motion. He sentenced Joshua Painabaz to life in prison with the possibility of parole after 25 years. Victims testified at sentencing. Their statements were described by observers and reporters as courageous and impactful. Judge Kawai acknowledged the bravery it required for victims, and, in some cases, the families and advocates speaking on behalf of victims too young to address the court themselves, to stand in a courtroom and face the man who had harmed them. Painabaz apologized at sentencing. He told the court he had changed, that he was sober now after years of struggling with addiction and depression, that he was a different person than the man who had committed these crimes. The court was unmoved. Judges in sexual abuse cases hear variations of this statement routinely. What speaks louder than the statement is the 12-year duration of the offenses, a 12-year span during which Painabaz could have, at any moment, stopped. He did not stop. He was ordered to pay $3,976 in restitution, a figure that cannot begin to quantify the cost of what these children and their families will carry for the rest of their lives in therapeutic work, in developmental support, in the years of effort required to begin healing from sexual trauma sustained at age 2 or 3 or 4. His nursing license was revoked. His name was added to the Kansas Sex Offender Registry. The question that remains for Manhattan, Kansas, and for the school district that employed him is how 12 years of access to small children was not interrupted sooner. What signs existed that were not acted upon? Whether any adult in any professional capacity observed behavior from Painabaz that might have raised concern. Whether any child, in any prior year, said something that was not recognized for what it was. These questions do not have publicly available answers. What has publicly available answers is the court record, the sentence, and the fact that Joshua Painabaz will not be eligible to seek parole for 25 years. The victims of this case are the youngest in this entire documentary. Some of them, at the time of the abuse, were not old enough to form the kind of memories that adults carry. Some of them will grow up knowing what happened to them only because someone else documented it, reported it, preserved it. They did not choose to be part of this story. They were placed into it by an adult who betrayed every professional and moral obligation he held. Their names are protected. Their courage, and the courage of the adults who believed them and fought for them, is not. This has been Case 8. Joshua Painabaz, former preschool nurse, Manhattan, Kansas, sentenced July 6, 2023 to life in prison with the possibility of parole after 25 years. Crimes spanning 12 years. Victims as young as 2 years old. Take a breath. Share this video. And when you come back from the break, Case 9 involves a nursing home in Bel Air where a 90-year-old woman's broken bones told a story her voice no longer could. Case 9, Jose Luis Reyes Jr., Bel Air, Kansas, 2022 through 2023. And the victim in this case never got to speak about what happened to her. By the time the investigation identified what had likely been done to her, she was gone. The evidence that told her story was not a witness account or a confession or a surveillance recording. It was her body, Specifically, it was what an autopsy found inside her body after she died on December 10, 2022. Reyes was 31 years old. His title was Certified Nurse Aide, CNA, a category of healthcare worker that provides direct patient care in nursing facilities. CNAs assist residents with daily activities: bathing, dressing, repositioning in bed, transferring from bed to wheelchair and back. They are the people who are closest to nursing home residents on a daily basis. They have more physical contact with residents than almost any other category of staff. And in that physical contact, in those moments of lifting and moving and assisting bodies that can no longer move themselves, there is an enormous potential for harm. Reyes worked at Catholic Care Center in Bel Air, Kansas, a small city immediately northeast of Wichita in Sedgwick County. The facility is operated by a Catholic Health Services organization and serves elderly residents requiring skilled nursing care. The 90-year-old female resident, whose death triggered this investigation, had specific documented care needs. Her medical records established that she required a minimum of 2 people to safely move her at any time. This was not a precaution. It was a clinical requirement established because her age, her physical condition, and her vulnerability to injury made single-person transfers actively dangerous. The 2-person requirement was in her chart. It was known to the staff. It was, according to standard care protocols, the legal and professional standard for her daily handling. Facility surveillance footage captured an image that became central to the investigation: Jose Luis Reyes Jr. entering the victim's room alone on the day of her death. He was alone. The 2-person transfer requirement was documented. He was alone anyway. Shortly after that recorded entry, the woman died. The primary cause of death was determined to be heart disease. She was 90 years old, and heart disease was an established condition. But the autopsy did not stop there. The medical examiner also found something that heart disease does not explain: broken bones in her legs, bruising under her armpits, consistent with being grabbed and moved, a bruise to her head, broken bones in her legs. She was a 90-year-old nursing home resident who required 2 people to move her and who was entered by 1 person alone before her death. The injuries documented in the autopsy were consistent with a single person attempting to move a frail, elderly resident without the required assistance, handling her in a way that produced fractures and bruising, the kind of injury that occurs when bones that have become brittle with age are subjected to force that exceeds what they can bear. Whether the intent was to harm her or whether the injuries resulted from reckless disregard for her care requirements is a question the investigation addressed, but the outcome was the same. A 90-year-old woman had broken bones and bruises that she did not have before Jose Luis Reyes Jr. entered her room alone. Prosecutors in Sedgwick County charged Reyes with felony mistreatment of an elder person, a charge that carries meaningful legal weight in Kansas, reflecting the state's recognition that crimes against elderly residents of care facilities are categorically serious. The case moved through the Sedgwick County District Court before Judge David Kaufman. In July of 2023, Jose Luis Reyes Jr. entered a guilty plea to the felony mistreatment charge. He was sentenced to 1 year of probation. He was ordered to surrender all Kansas medical care certifications, meaning his CNA certification was revoked, and he could no longer work in any capacity requiring a Kansas healthcare credential. The sentencing order also specified that if Reyes violated any condition of his probation, he would serve 9 months in the Kansas Department of Corrections. Probation. For a felony. For a case involving a 90-year-old woman who died with broken bones in her legs after the 1 person responsible for her care entered her room alone in violation of documented medical protocols. The sentencing outcome in the Reyes case reflects a pattern that advocates for elderly nursing home residents have documented extensively. Criminal prosecutions of care facility workers for patient abuse and neglect tend to result in outcomes: probation, light sentences, misdemeanor charges that do not reflect the severity of what occurred. Part of this is structural. Death in a nursing home resident is often anticipated, and establishing that specific actions by a specific worker caused or materially contributed to that death requires forensic pathology, documentary analysis, and witness testimony that courts sometimes find insufficiently certain to support harsher sentencing. But part of it is also a reflection of how our legal and cultural systems value the lives of elderly people. particularly elderly people with significant health conditions, cognitive decline, or advanced age. A 90-year-old woman with heart disease is not expected to live forever. The question of whether her broken legs and her head bruise shortened whatever time she had left, and by how much, is genuinely difficult to answer with forensic certainty. Prosecutors and defense attorneys both know this. Judges know this. And the result, in cases like Reyes's, is often a sentence that feels fundamentally inadequate to the harm that occurred. The 90-year-old woman at Catholic Care Center in Bel Air did not receive the standard of care she was entitled to. She was entered by a person who had been told, in black and white, that she needed 2 people present whenever she was moved. That person was alone. She had bruises under her armpits. She had broken bones in her legs. She had a bruise on her head. And she died. She deserved better. Every resident of every care facility in the state of Kansas deserves the protection of mandatory transfer protocols, adequate staffing, adequate oversight, and adequate accountability when those protections fail. Jose Luis Reyes Jr. will not work in Kansas healthcare again. That is something. But the woman whose room he entered alone on December 10, 2022 deserves to be remembered as more than a cautionary statistic. This has been Case 9. Jose Luis Reyes Jr., Certified Nurse Aide, Catholic Care Center, Bel Air, Kansas, pled guilty July 2023 to felony mistreatment of an elder person, sentenced to 1 year of probation. All Kansas healthcare certifications surrendered. 1 case left. Case 10 is the case that brings together everything this documentary has been about: institutional failure, system-wide vulnerability, and the question of who is watching. Stay with Crime Doc. Case 10, the Kansas Nursing Board Crisis and the Pattern that Connects Them All. Statewide, 2005 through 2026. There is no single name for this one, because this case belongs to all of them. This documentary has taken you through 9 individual cases: 2 people who enslaved the mentally ill for 20 years, a nurse who assaulted surgical patients who were too sedated to fight back, a traveling technician who infected Kansas patients with a deadly virus, a nursing home where 63 residents were abused and an entire night shift stayed silent, a nurse who drugged an elderly dementia patient and then texted a photograph of the unconscious woman to a colleague, a nurse who stole fentanyl from 4 Kansas hospitals over multiple years, 2 more nurses who stole fentanyl and hydromorphone and replaced them with saline and sterile water, a preschool nurse who sexually abused children as young as 2 for 12 years, and a certified nurse aide who entered a 90-year-old woman's room alone, in violation of documented medical protocols, and left her with broken bones. 9 cases, 9 perpetrators, dozens of institutions, hundreds of victims, and running through every single one of them is the same thread. Someone knew, someone saw, something was documented. A complaint was filed, a protocol was established, a background check was run, a concern was raised, and the system that was supposed to act on that information failed to act on it in time to stop what came next. 12 abuse complaints filed about the Kaufman house over 12 years, not acted upon until the FBI raided in 2004. 2 police investigations at Menorah Medical Center before Dennis Clark was allowed to walk out and be hired at Providence. For prior hospital firings for David Kwiatkowski before he reached Hayes Medical Center. An entire night shift at Victoria Falls who knew about 63 abuse victims and stayed silent because they believed nothing would be done. For institutions where Julie Grant exhibited suspicious behavior involving controlled substances before she reached HCA Midwest. 12 years of Joshua Painabaz working around small children. These are not coincidences. These are symptoms. And the final case in this documentary, the institutional case, is about the Kansas State Board of Nursing and the recognition, now reaching the Kansas State Legislature, that the oversight body responsible for ensuring that licensed nurses practice safely has itself become a subject of intense scrutiny. The Kansas State Board of Nursing licenses more than 74,000 nursing professionals across the state. It investigates complaints, conducts hearings, and has the authority to revoke, suspend, or restrict nursing licenses when professional misconduct is established. It is the last line of defense between a dangerous practitioner and a future victim. In February of 2026, just this year, as this documentary is being produced, the Kansas House of Representatives unveiled House Bill 2528. The bill proposes something extraordinary. It would void all Kansas State Board of Nursing disciplinary actions taken between 2005 and 2026. 2 decades of disciplinary actions. Gone. The legislative movement behind this bill grew out of a significant number of nurses who complained that the nursing board had been overly aggressive, that nurses had faced license sanctions for minor documentation errors, clerical mistakes, and technical violations that had nothing to do with patient safety. Nurses who felt the board had become a punitive body rather than a protective one. Nurses who felt due process had been compromised. These complaints deserve to be taken seriously. An oversight body that punishes nurses for clerical errors while failing to stop the kinds of systemic patterns documented in this documentary is not effectively serving patient safety. It is creating the appearance of enforcement while missing the substance of what enforcement is for. But here is the tension that House Bill 2528 creates. If all board disciplinary actions between 2005 and 2026 are voided, what happens to the records of nurses who were sanctioned for genuine patient harm? What happens to the paper trail that tells the next employer what happened at the last one? What happens to the architecture of accountability, however imperfect, that prevents a nurse with a disciplinary history from simply moving to the next job, the next hospital, the next care facility, the next patient? Dennis Clark was investigated at Menorah Medical Center. The board was never notified in time to create a record that would have followed him to Providence. David Kwiatkowski did not have his misconduct tracked at all because he was a technician rather than a nurse. The gaps in the tracking systems are already costing patients. And a bill that voids 2 decades of disciplinary records, even in service of legitimate concerns about regulatory overreach, risks widening those gaps further. The real answer to the Kansas nursing oversight crisis is not to void the records. It is to build a system that is simultaneously more accurate in its targeting of genuine misconduct and more effective in its response to genuine patient harm. A system that does not punish nurses for documentation errors while allowing repeat drug diverters to move between hospitals. A system that can share information across state lines so that a nurse who left a hospital in Kansas under suspicious circumstances cannot immediately apply for a position in Missouri without that history following them. The National Nurse Licensure Compact already exists, a multi-state agreement that allows nurses to practice in member states under a single license, and that creates some level of shared information. Kansas is a member, but compact membership does not solve all information-sharing gaps, particularly for the categories of misconduct that may not result in formal board action before a nurse moves on. The deeper issue, threaded through every case in this documentary, is one of institutional culture. Hospitals and nursing facilities are not merely workplaces. They are environments built on trust. The trust of patients who have no choice but to believe the people caring for them mean to help. When that trust is systematically exploited, the damage is not merely individual. It is structural. It erodes the foundation of what healthcare is supposed to be. Linda Kaufman held a nursing license for more than 20 years while her facility was the site of horrific abuse. Dennis Clark held a nursing license while he assaulted and anesthetized patients at 2 hospitals. Julie Grant held a nursing license while she stole fentanyl from at least 4 institutions. Joshua Painabaz held a nursing license for 12 years of child sexual abuse. The license was supposed to be a guarantee. The license meant that the state of Kansas, through its nursing board, had verified that this person met the standards required to practice nursing safely. In every one of these cases, the license failed to function as that guarantee, not because the licensing standards were wrong, but because the systems for monitoring, reporting, and acting on violations were inadequate to the scale and duration of the harm being committed. The Kansas Nursing Board is under legislative pressure to reform. The legislature is right that reform is needed, but the direction of that reform matters enormously. Voiding 20 years of disciplinary records is not reform. It is erasure. And erasure, in the world of patient safety, is dangerous. The patients of Linda and Arlen Kaufman deserve to know that the nurses who supervise their exploitation cannot simply have that record disappear. The patients of Dennis Clark deserve to know that the board's record of his misconduct is preserved as a permanent part of the institutional memory of who he was and what he did. The 90-year-old woman at Catholic Care Center deserves to be part of a record that says Jose Luis Reyes Jr. surrendered his healthcare credentials, and here is why, and here it is documented permanently. Records are not perfect. Oversight is not perfect. No system built and run by human beings is perfect. But the alternative, a system that produces no records, that has no memory, that gives every practitioner a clean slate regardless of what preceded it, is not protection. It is an invitation. What can you do? You can know who is caring for your loved one. You can visit without notice. You can ask questions about staffing levels and incident reporting. You can document what you observe. You can install a camera in a nursing homeroom, consult your state's laws, and in Kansas, as in many states, this is permissible. You can report concerns to CDADS, to the Kansas Attorney General's Medicaid Fraud Control Unit, to the Kansas State Board of Nursing, and to the FBI if the conduct may involve federal violations. You can advocate for better disclosure laws that would require nursing facilities to tell patients when a drug diversion event has occurred in their care setting. And you can remember the names in this documentary. Not the perpetrators. They have taken up enough space. The victims: Eleanor Murphy of Hayes, Kansas; Donna Culture of Andover; the residents of the Kaufman House; the patients of Dennis Clark; the children harmed by Joshua Painabas; the 90-year-old woman of Bel Air who went to a care facility because her body needed help and whose body was found with broken bones. They trusted the system. The system failed them. And the least we can do, the very least, is refuse to look away. This has been Case 10, the institutional failure that runs through all of them. Kansas statewide, 2005 through 2026. Ongoing. You have been watching Crime Doc. 10 cases. 10 examples of what happens when people in positions of medical trust abuse the power they have been given. 10 reasons why accountability in healthcare is not bureaucracy, it is survival. If this documentary helped you understand these cases better, if it moved you, if it made you think differently about the system that is supposed to protect the people we love, please like this video. Every like tells the algorithm that this content matters. And it does matter. Comment below, which case affected you most? Have you or someone you love experienced inadequate care in a Kansas medical facility? What do you think needs to change in nursing oversight? This community matters. Your voice matters. Subscribe to Crime Doc and hit that notification bell. Every week, we bring you documented true crime, victim-centered, factually verified, told with the gravity and the respect these stories deserve. The victims in these cases were not statistics. They were people. Eleanor Murphy loved her community in Hayes. Donna Culture had a family that fought for her. The children harmed by Joshua Painabas have futures ahead of them that they are fighting to reclaim. The residents of Kaufman House endured things no human being should endure, and some of them lived to testify about it in federal court. We tell these stories so their experiences are not erased. So accountability is documented. So the next person who enters a care facility and feels something is wrong has a framework to understand what they are seeing and what they can do about it. That is what Crime Doc is for. Until next time, stay curious, stay vigilant, and never stop asking questions.